Hello, my name is Dean Reynosa, and I have been practicing law for more than 20 years here in Pennsylvania. During that time, I have represented clients before state and federal judges, juries, appellate courts, as well as local municipal bodies. My primary areas of practice include civil litigation, land use, and appellate practice. My plan here with this video is to briefly discuss some aspects of the land use hearing and appeal process and why its careful attention should be taken when presenting your project to the local municipality. The first step in any project would be to review the local municipal requirements for your solar project. We have a separate video on our website discussing this application process. While there are many pathways for a solar development project, some of the most common applications involving hearings are applications for special exceptions before a zoning hearing board or applications for conditional use approvals before the local governing body. After the applications are filed with the supporting documentation, hearings will be scheduled by the municipalities. These hearings will be recorded by a stenographer, so careful attention is required to make sure the record is clean, comprehensive, and accurate, since it is the developer's burden to establish its request for a particular use. Developers should be prepared with a knowledge of zoning requirements and a battery of experts in order to satisfy their burden at the hearing in order to obtain approval for the requested use. Our firm, MPL, has years of experience, and we strive to ensure that we create a comprehensive record for consideration for the local municipal board on behalf of our developer clients. Once scheduled, these hearings are required to be advertised to the local community. It is not uncommon to encounter at hearings individuals that may oppose a project. However, it is important to determine whether these individuals should be identified as a party objector for the record. A party objector may be provided an opportunity to question your witnesses or appeal any final decision by the municipal body. If an individual does not qualify as a party objector, they would still be afforded an opportunity to offer public comment in support of or in opposition to a project, but generally such individuals will not have the opportunity to appeal an approval of the project. It is important to identify for the record whether anyone from the public is participating as a party opponent, and we try to do that at the outset of the hearing. After the close of the record, the board typically has 45 days in which to render a written decision concerning the application. With a favorable ruling, generally only those individuals who sought and had been granted party objector status would be entitled to pursue a land use appeal to the Court of Common Pleas, which is our local trial court. With an unfavorable ruling, the developer would also have the opportunity to file an appeal to the trial court. Typical standard of review for these land use appeals is whether the municipal board's decision is supported by substantial evidence. Land use appeals are usually decided by the trial court based upon the record that was developed and preserved before the municipal body. This is why it's important to ensure that a developer comes prepared with reports and experts to present the best case at the municipal level, so any appeal from an approval will be supported by substantial evidence. There are some times where additional evidence may be presented before the trial court on appeal, but it is not the typical scenario. Careful attention should also be taken to monitor when the written decision is issued by the municipal board. These decisions must be issued within a set period of time after the close of the evidence. If a written decision is not timely issued, the developer may be entitled to a deemed decision for approval. The ideal situation is that there would be no appeal to approval, since any appeal would typically delay a project by at least 9 months. This video is intended as a high-level view of the land use hearing and appeal process. Every case is different, so it is important for any developer to discuss its particular situation with counsel. In the last 4 years, our firm, MPL, has achieved 42 solar project approvals statewide. We have represented solar developers in most parts of Pennsylvania. Please reach out to us if you have any specific questions about your particular solar project.